Ask Archie's phone password.
No, why do we need power?
No, not on this. Move little left side. Power button is coming.
Move the camera, phone left side.
Little. Give that.
Anshu.
Go back to the audio.
90056.
90056.
I switch on my audio, switch on my Zoom. Done.
90056.
Not you guys.
Yes.
Pull it up, please. This is fine. Correct.
Oh yeah, there's option.
Yeah, it'll start now.
It's not. It will. No, we turned it around. Actually, YouTube. Okay, yes.
It has
perfect.
gone.
Look at this.
This is Zoom. You just stay here and now I'm gonna hold it on me.
I could hear you. My friend.
Start now. Yeah, my-
So you can start. Once the tribunal, before we proceed, may the claims counsel direct the respondent counsel with regard to the audit procedure. Respondent counsel is very legal would like to follow. Please stick to the default procedure. That's a management. Thank you so much. Mr. Presiding Arbitrator, members of the tribunal, and my esteemed colleagues, good evening. By way of introduction, my name is Siddharth Shroff, and I am here on behalf of the claimant, Blackfield GmbH, in this arbitration. Over the course of the next 15 minutes, I shall be addressing the tribunal on the procedural aspects of this dispute, while my co-counsel, Mr. Rishabh Deshpande, will be addressing the merits. We respectfully reserve 5 minutes for rebuttals. Despite upholding the contract with the respondent, the claimant has been met with opposition regarding a valid joint claim and also with disputes with respect to the Singaporean seat of the arbitration. These issues, coupled with the merits of dispute, find us before this arbitral tribunal. In my speech, I shall first address issue 1, admitting AAI as a joiner in this arbitration, And secondly, addressing the receipt of the arbitration as payable. With regard to our first issue, members of the tribunal, it is seen that with regard to a third-party joiner, Rule 7.8 of the SEAC rules have been fulfilled. Under Rule 7.8 of the SEAC rules of arbitration, it is seen that a non-signatory may be joined as a party to the arbitral proceeding if they are established by way of a prima facie contention being fulfilled. It is seen here in the case of Shin-Etsu Chemicals versus Akshapta Fiber at paragraph 41, that participation in negotiation or the performance or the furtherance of a contract implies inclusion in proceedings. In the present case, members of the tribunal, it is seen that there is an evident valid arbitration agreement between the parties alongside AAI's privatization and partnership agreement they have with the respondent. Furthermore, this contract between the claimant and the respondent was a valid consequence of this very PPA. It was further stated in the letter of comfort that had been issued by the Airports Authority of India that the claimant's cooperation would be looked upon as favorable. Now I understand, members of the tribunal, it would be a valid contention that would pose a lot of money with regard to why does a letter of comfort, a seemingly placatory measure, be considered to have legally binding value here. Well, it is contended by the claimant's counsel that with basis in the case of, if the counsel may request a moment. Absolutely. With respect to the case of Australian National Industry, it was contended here that with regard to letters of comfort that have been issued, the binding value they have on an arbitration agreement or on a party would be ascertained with respect to the circumstances involving it. Here, we see the vociferous involvement of the Airports Authority of India in the negotiations of the dispute as well as the negotiations of the contract that has been formed between the claimant and the respondent. We see that the Airports Authority of India is a state entity construed to be the state under Article 12 of the Indian Constitution. Now, with regard to a state entity, the Airports Authority of India that administers a total of 137 airports across the Indian territory. 103 of these being domestic airports, 24 being international ones, and 10 being customs airports. We see that the involvement of the chief secretary of this state entity in one particular airport with regard to a very specific privatization and partnership agreement that was made for the sole purpose of increasing traveler experience and bettering the same or modernizing the same airport with regard to simply one airport is seen as a little commercially unviable unless members of the tribunal, the Airports Authority of India was implicitly involved in the negotiations of this particular contract. At various junctures of the fact sheet, we notice, and if it may please the tribunal, turn to first, page 5 of the note proposition to paragraph 12. Are the members of the tribunal with me? Much obliged. Here, we see AAI's involvement in the Zoom meeting that we did. At various other junctures of the fact sheet, which I will not require, or which I would not request the members of the tribunal to turn to, but for their convenience, I will summarize that with reference to various paragraphs like those of 16 and 18, it is seen that firstly, money that was owed by the respondent to the claimant was transferred directly by the Airports Authority of India to the claimant. This money was owed by the respondent, and the Airports Authority of India, currently on the face of it, had no obligation to make this transfer unless they decided to implicitly involve themselves here. I understand the respondent's counsel would allege that there is some sort of incidental involvement, which the counsel here concedes that incidental involvement is not material enough to be implicit consent. But when such a huge money transfer takes place, and also in light of disputes that took place between the claimant and respondent while negotiations with regard to contractual clauses were taking place, the Airports Authority of India, especially the Chief Secretary of the same, who I reiterate, has to manage 137 airports with regard to many other jobs or tasks that the job description brings to him. The mediation of this one particular sale and purchase contract, unless he wished to implicitly involve the Airports Authority of India, was not required. Furthermore, it is seen that we concede, the Critics Council concedes that we requested the implicit involvement of the Airports Authority of India. But this was because we, as a German company, are seen that the respondent, a company that has been incorporated in India, who we have never contracted with, we required a certain level of appeasement or a certain level of placation with regard to who we were getting into a contract with. Now, the circumstances purport that the Airports Authority of India, at every juncture of negotiations, was involved here. So, with them issuing a letter of comfort to placate our concerns would essentially show that with their involvement here, they would purport some level of intentions to bind themselves. Also, it is seen that with regard to the meeting that took place in Mumbai, when the contract was in its nascent stage, it wasn't, the negotiations hadn't even begun. The discounts the Airports Authority of India sought on behalf of the respondent from the claimant in the contract, alongside being copied to every email and being present at every single negotiation meeting, it showcases a large and substantial involvement on the part of the respondent and that of the AAI. Further, members of the tribunal, it is also noticed here that with regard to Article 20 of the Sale and Purchase Agreement, which is present on page 11, if the members of the tribunal may please turn to the same. Are the members of the tribunal with me? Much obliged. We see here under Article 20 that the Airports Authority of India bears right. They do bear right to the notification. They are eligible to notifications of changes that take place in the contract or with regard to any negotiations that take place with regard to the same. But here, when they are entitled to the notification, why would they involve themselves in every meeting? Their notificatory entitlement does not entitle them to be the mediator in their disputes. It does not entitle them to make money transfers on behalf of the respondent. And these all clearly showcase their implicit involvement. Furthermore, it is seen that with regard to our submission, the Chief Secretary of the Airports Authority of India was overseeing this one minute sale and purchase contract. To contextualize it, the Ministry of Civil Aviation of India on the 6th of February in 2023 issued through the Press Information Bureau of India that they were modernizing and upgrading over 100 airports within 1 year. And this was solely with regard to modernization of the same. At the same time, new airports were also being developed. And this was again, to reiterate, one of the several tasks that the Airports Authority of India has. When they claim that their role was merely supervisory, the role of the Chief Secretary cannot be said to be supervisory in an extremely minute contract in the larger scheme of things. And it is also submitted by the Claimants Council that they are deriving some sort of benefit from the same, as has been seen if the members of the tribunal would please turn to paragraph 18 of the note proposition on page 6. Are the members with me? Members of the tribunal, here we see under paragraph 18, Mr. P.R. Rahman attended yet another meeting, and in this meeting, he clarified to the claimant as well as the respondent that with regard to the execution of this very contract, the contract would, if the contract was not executed the way it was supposed to be, they would accrue reputational damages. Now, if this would imply that the smooth sailing of the contract and the perfect execution of the same would lead to reputational benefits accrued by them, we clearly established that through this, they are accruing benefits and thus have high stakes by way of the revenue sharing agreement as under the privatization and partnership agreement. Every little step, be it the HTBC being installed at the airport, enhances consumer and traveler experience. It modernizes the airport. This contract would be in furtherance of the privatization and partnership agreement, thus leading to a substantial level of implicit involvement, which thus establishes through both prima facie contentions being satisfied as well as implicit consent being satisfied, the Airports Authority of India may be admitted by way of joinder to this present arbitration.
Can I ask you a question?
Certainly.
Do you have any judgment where a non-signatory was made a party on the ground of involvement in the negotiations?
Certainly, Madam Arbitrator. In the case of Shin-Etsu Chemicals versus Akshobhya Fiber, it had been noted that participation in negotiation and performance of the contract implies a non-signatory's inclusions in the proceedings.
In this particular case, Mr. Rahman may have been interested in the contract between the claimant and the respondent proceeding, but is that sufficient to show that Rahman was actually, or AI was bound by such an agreement? Because they are obviously non-signatories. They were interested in the agreement between them and the respondent going ahead in that contract, because they were signatories of that contract. But so far as the other contract is concerned, they may have only been interested in seeing that proceeded with the contract. So is that sufficient? That's the question.
Yes, Mr. Presiding Arbitrator, it seems that the same is sufficient to contend AAI by way of a joinder, as it is again submitted by the claimant's counsel that with regard to the role of the Chief Secretary, in particular, one of the apex positions, a linchpin in a company, especially a state entity, someone who enters into large-scale contracts on a daily basis, with regard to one particular sale and purchase contract, just for the admission of a few diverters with regard to baggage conveyance, I doubt with regard to the same, the Chief Secretary would be present at every single negotiatory meeting when they themselves had right to notification of the changes that took place. Seeing that I have fulfilled the submissions from my end with regard to the joinder,
Of comfort. It doesn't, it's only reassuring, it doesn't commit to anything. So how can you say the parties are bound because there is a letter of comfort being provided?
I understand your concern, Madam Arbitrator. Here it is submitted that if we don't just look at or don't solely look at the language of the letter of comfort, but also admit it with regard to the circumstances it was issued, please see, if it may please Madam Arbitrator and the rest of the tribunal, return to page 13 of the moot proposition to Annex B. Here is if the members of the tribunal are with me. Much obliged. Here, under paragraph 4, we see that when the claimant specifically asked Mr. P.R. Rahman, the Chief Secretary of the AI, to showcase some amount of involvement, some official involvement as seen towards the middle of the paragraph in this particular agreement. They not only asked for discounts on behalf of the respondent, showcasing some sort of material stake, as when we notice the concept of revenue generated would be higher if the costs incurred by the company submitting claim would be less. And secondly, upon the ask or because of the request of official involvement of the Airports Authority of India, only then was this letter of comfort initiated, which is why it is submitted that it should be binding on the Airports Authority of India. Members of the tribunal, seeing that I am at almost the lapse of my time, may I request an extension to summarize my arguments on the seat of the arbitration? Much obliged, Mr. Presiding Arbitrator. With reference to our second issue, members of the tribunal, it is submitted and contended by the claimant's counsel that the seat of the arbitration is Singapore. This is submitted since first, the venue and the seat of the arbitration are not antithetical to each other, and second, the conduct of the parties affirms Singapore as the seat of the arbitration. Under our first submission, members of the tribunal, it is seen that unless a contrary indication appears, as seen in the case of BGS SGS Soma versus NHPC, the absence of an expressly stipulated seat would mean that the designated venue is the seat of the arbitration. This particular case cited by the claimant's counsel of BGS SGS Soma propounds the Shashua principles that were present in the Roger Shashua versus Mukesh Sharma judgment. And when the parties agree on a neutral venue of arbitration, since one of the parties is incorporated in India and the other is a German limited liability company, we see that Singapore is a neutral venue. And as was seen in the Brahmani River Pellets versus Kamashi Industries judgment, when it comes to the designation of a neutral venue, the designation of the location confers the jurisdiction on the local courts of that venue to the exclusion of all other courts. Thus, it is seen, and while I understand the respondent would allege the presence of the Indian Arbitration and Conciliation Act in Annexure A, Clause 22, Paragraph C. Mr. Arbitrator, you have some speak that.
You mentioned the arbitration clause, just arbitration in Singapore. The clause is not seen as the model clause that was suggested by the Singapore International Arbitration Center. In the model clause, it's quite clear, there's a separate paragraph that says the seat of the arbitration shall be Singapore. Why did the parties then not use such a clear language in this case? It looks like a less clear language than what you have in the clause, so are you sure?
I absolutely understand as to the arbitration clause's requirement to be succinct, but the model clause issued by the SIAC rules is merely suggestive. It is not the exact way in which the arbitration clause should be purported. While I understand Mr. Arbitrator's concern as to why is it not so clearly worded, in the absence of clear wording, we would request the members of the tribunal to consider the implicit meanings herein. Firstly, if the members of the tribunal could please turn to page 12 of the moot proposition. Are members of the tribunal with me? Here we see that with regard to Article 22, which is the dispute resolution clause, Clause A and Clause C, subclause A and subclause C bear two mentions of Singapore. Firstly, it states without direct involvement of the SIAC rules as under subclause A, it is seen that arbitration should take place in Singapore. And secondly, under subclause C, it signifies that the venue of the arbitration shall be Singapore. If the language of this arbitration agreement is considered, it is seen that two spots in the arbitration agreement symbolize Singapore both as the venue and with regard to the seat of the arbitration. Furthermore, it is seen that with regard to the contrary indication that may be alleged by the respondent with regard to the Indian Arbitration and Conciliation Act being present, if the council may request a moment. It is seen, members of the tribunal, that the agreement was formed in 2021, very close to the 2015 amendment to the Indian Arbitration and Conciliation Act. This amendment said that Part 1 of the ANC Act would implicitly apply to foreign seated arbitrations as well. But this was not the case before this particular amendment. This is present because of residual confusion regarding legislative positions, and hence, so as to include Section 9 and Section 27 and other sections which would assist in the furtherance of dispute resolution. The same has been admitted as the Indian Arbitration and Conciliation Act here for the same purposes. And this has been seen in the Delhi High Court case of the Raffles case, which is why in a foreign seated arbitration, the mention of the Indian Arbitration and Conciliation Act has also been made. With regard to our last subject, yes, Madam Arbitrator. Yes. The year was 2021, Madam Arbitrator.
So that is post the 2015 amendment, which says that the Part 1 would apply unless the parties chose not to apply. So if they did not want to have Part 1 applied, they had to say so. They did not have to specify it would apply because it would automatically be applicable to you. So your argument sort of doesn't make sense.
Madam Arbitrator, to clarify the same, the claimant alleges that with regard to residual confusion regarding the legislative position on certain areas of point law, as has been seen, as the claimant submitted with regard to the Raffles case, it was seen that despite having a seat of arbitration that was a foreign seat and not an Indian seat, the same was included despite Part 1 of the ANC Act being implemented. The submission is not that it was included to include the same, but it was included so as to clear up any residual confusion with regard to the legislative position.
But once the law is clear, where is the confusion? The confusion would have been prior to 2016 made it very clear that part 1 is available to you.
I understand that, Madam Arbitrator.
Could it be that the parties actually intended India to be the seat and therefore Indian Arbitration Act to apply, and for all other purposes the venue is Singapore?
Respectfully, Madam Arbitrator, we disagree. But since the current contention of the claimant shall not satisfy the members of the tribunal, we shall move to a final submission, which is with regard to the notice of arbitration that the claimant issued to the respondent. Members of the tribunal, if it may please the tribunal to turn to page 7 of the moot proposition, to paragraph number 22. Members of the tribunal, we see here that in the notice of arbitration, it was explicitly stated by Blackfield that the seat of the arbitration was Singapore. Now, if we look at Rule 4.1c of the Act rules, it states that within 14 days of the notice of arbitration being issued, a statement of defense or a statement of reply would be issued by the respondent shall they have any contentions with regard to anything present in this notice of arbitration. 4.1c of the Act rules, members of the tribunal, further states, so further points us to 3.1c, or 3.1 rather, of the Act rules. Under 3.1c of the Act rules, members of the tribunal, it is seen that claims with regard to the arbitration agreement shall they be contested or shall they be questioned by the respondents have to be made a reply or an objection to. This lack of response from the side of the claimant clearly waives their right to object here with regard to Singapore being contended as the seat of the arbitration. And with this, if there is any concerns of the members of the tribunal that I made here. Certainly, Mr. Yes, Mr. Mr. Arbitrator, you are on.
You see, Article 22 subclauses C and E. Isn't that enough indication in the arbitration clause itself that the seat will be India for all practical purposes? Because the reference there is to the Indian Arbitration Conciliation Act, and the agreement is also governed in accordance with the laws of India. So wouldn't those two concomitants put together mean that the seat for all practical purposes is India?
I understand your concern, Mr. Arbitrator. With regard to the same concern as has been raised by Mr. Arbitrator, we see that when the venue of the arbitration is mentioned and the seat is not mentioned, in a lot of cases, parties have tried to apply the close connection test. This close connection test was derived from the Sul America judgment, which seek to find the law of the arbitration. It didn't seek to find the seat of the arbitration by way of the laws included in the arbitration agreement. And thus, the claimant's counsel submits that with regard to the particular case that we find ourselves in, where only the venue of the arbitration is specified and there is no contrary indication as has been submitted with regard to a contention on the input of the Indian Arbitration Conciliation Act, we see there being no contrary indications in our submission that the seat could be construed as the venue. Should this clarify and satisfy all questions of the members of the tribunal, the claimant's counsel on procedure as their case? It was an honor arguing before this tribunal. Thank you so much.
If I may confirm if I'm audible. Mr. President, members of the tribunal, we appear to the respondent Usagi Airports Terminal this arbitration. Over the course of the next 18 minutes, I shall be addressing the tribunal on the first two questions and making two broad submissions. First, that AI cannot be joined to this arbitration. And second, that Article 22 on a reading would show that India is the seat of this arbitration. At the outset, this tribunal must see the joinder application of the claimants for what it actually is, a second bite at the cherry. I say this because of para 23 and 24. This tribunal will look at page 7 of the fact sheet. This tribunal is there. On 31st October 2023, that we filed an application under Rule 7 of the CIAC rules to join AI as a respondent in the pending arbitration. On 10 November 2023, the CIAC conveyed the decision of the CIAC Court of Arbitration to the parties rejecting the application for the joinder of AI. This attempt has already been effectuated by the claimants already. The CIAC Court has rejected the joinder application. In this particular circumstances, the joinder application of the claimant is under Rule 7.8 of the CIAC rules. It provides for two criteria for this tribunal to effectuate the joinder. The first is the prima facie existence of an arbitration agreement, prima facie being the key word. Secondly, that all parties, including the additional party to join, have consented to the joinder. It is our case that neither of these criteria are even remotely met in this arbitration. Members of the tribunal, parties to an arbitration agreement are determined by the signatories to the contract or the underlying arbitration agreement. In this case, AI is neither a party to the SPC nor to the underlying arbitration agreement. Therefore, on the prima facie proof itself, satisfying the test on the first test under Rule 7.8, this tribunal must hold that AI cannot be joined in this arbitration. In any event, the key determinant to see whether additional parties sought to be was actually intending to be a party to the arbitration agreement is the party's intention to create legal relations. In this case, it is our submission, there are no legal relations between AI and the parties to the SPC. We say this because of two main reasons. First, the doctrine of privity, and second, the letter of comfort. Members of the tribunal, the doctrine of privity provides that the contract cannot confer rights or liabilities on any person apart from the parties to the contract. Since an arbitration agreement is also a creature of contract, doctrine of privity prevails, and also an arbitration agreement must be construed as per the doctrine of privity. In the instant case, there is no privity between AI and the parties to the SPC. This is because the SPC was entered in for the limited purpose of procuring 4 horizontal diverter baggage conveyors. AI has had no involvement in this particular matter. Secondly, coming on to the letter of comfort, this tribunal had addressed some concerns, had raised some concerns with regard to the legal binding, legal liability that's created by virtue of the letter of comfort. It is our case that ordinarily, a letter of comfort is merely a document that indicates one party's intention to ensure that another party complies with its obligations without actually guaranteeing the performance. This question came up before the Bombay High Court in the case of Yes Bank versus C Entertainment. The Bombay High Court was construing whether a letter of comfort amounted to a guarantee, and it went on to say that a letter of comfort would only create legal liability when there was an unambiguous affirmation of legal liability. If this tribunal would look at para 5 on page 1, para 5 of the statement of facts, on page 4. If I may read, AI is in partnership with OAT for the modernization of the Mysore International Airport and is committed to ensuring the success of this project. AI will provide all appropriate support for the successful completion of the project on behalf of OAT. Your cooperation will be viewed favorably, including in future procurement pertaining to the Mysore International Airport. It is our submission that on a bare reading of the LOC, it is indicated that AI has only indicated its commitment to ensure the success of the MIN project. It has merely indicated its support on behalf of OAT without actually guaranteeing performance. That being the key determinant on whether a letter of comfort creates legal liability. As I understand it, my learned friend's case is that the arbitration agreement can be extended on the basis of the doctrine of implied consent. More particularly, the conduct of AI in the factual circumstances indicates its implied consent to be bound by the arbitration. It is our submission that AI's conduct cannot be indicative of its intention to be bound with the arbitration agreement for a very simple reason that AI is a statutory authority which controls and manages passenger terminals all over the territory of India. Owing to its position as a regulator, it is necessary for the AI and its officials to be present in the negotiations and any contract that is entered into for the development of an airport. As the learned friend has raised the argument on Article 20 of the SPC, which provides that any amendment or modification to the terms of the SPC will be indicated or notified to AI. This is for their necessity. A statutory body has the right to be informed of any developments with regard to an airport. This conduct of AI does not indicate its intention to create legal relations. It is complying with the statutory obligations. Therefore, it is our case that with regard to legal relations and the conduct of AI, these two grounds do not amount to its indication to consent to be joined to this arbitration. Further on, Rule 7.8b indicates or provides for another criteria. The criteria being that the consent of all parties, including the additional party to the arbitration agreement, is required. It is our submission that AI and OAD have both heavily objected against this joinder. In view of these objections, this tribunal cannot join AI to this arbitration as 7.8b is not met. If this tribunal effectuates such a joinder, it would amount to a forced joinder, which would be a major derogation of the principles of party autonomy.
Further, just one query. What about multiplicity of proceedings? Because if AI is not joined as a party, then there will be separate proceedings initiated by Blackfield against AI. So, what do you say about
it? It is our submission that Blackfield has no case either on merits or on substantive issues against AI. Therefore, there is no question of any other proceedings being raised. That is also why we heavily contest this joinder. Further on, if any arbitration is to be conducted with AI from by Blackfield, that must pertain to the arbitration agreement under the privatization partnership agreement. That is the only arbitration agreement that AI has submitted. It brings me to another solution that AI has never submitted to jurisdiction or to the has never submitted to the CI. It has never opted to the CI rules. Therefore, this court cannot use its power under Rule 7. This tribunal cannot use its power under Rule 7.8 to effectuate such a joint.
Bringing to Article 20 of the contract, is it your position that if there was no notification of amendment to AI, that AI would have no recourse against the parties? Is there a recourse for benefit for third parties?
If this tribunal may again clarify this question. If the tribunal may clarify its question.
Yes. In amendment, in Article 20 of amendments, it does say that AI has the right to be notified, shall be notified of any amendment. Does that confer any right to AI on the beneficiary of a third party? Does it have a right to recourse if they are not notified?
It is our submission that this requirement is a mandate under the SPC, which does not raise any substantive right towards AI. This is merely a requirement in the form of a procedural order. Therefore, does not raise any substantive right against AI in the favor of AI to raise a claim when it's not being notified under Article 20. Proceeding to the final submission of the point of joinder, this tribunal and any other arbitral tribunal has an obligation to render enforceable awards. Now, this principle is also embedded in Rule 41.2 of the CI rules. It is our submission that if this tribunal were to effectuate such a joinder, notwithstanding the consent, the objections of the parties, it would amount to a forced joinder as a derogation of party autonomy, and any orders of this tribunal may run the risk of being rendered unenforceable. So this is the thing. I sense a concern.
It's just a question. On page 6 of the fact 16, it says that US dollars 1 million was transferred by AI to Blackfield. And so just on the basis of what you mentioned previously, we're told here is an increased consideration given and there is a benefit received. So does this not create some relationship indirectly with Blackfield?
I understand this tribunal's question. If I may read Article 16 to merely clarify what it actually, Para 16, to merely clarify what it actually provides. On 5 June 2023, OIT's Ms. Sundari called Blackfield CEO Mr. Johan Becker and informed him that AI was willing to immediately transfer USD 1 million to Blackfield directly, being amounts due from AI to OIT. These were amounts due from AI to OIT, and this was directly effectuated so that the amount would go from AI to Blackfield. This was no intention to create a legal relation. It was merely a matter of convenience. Moving forward, if this tribunal has any other concerns, if I may proceed.
Sorry, just one. Your first submission was that joinder is not permissible because AI is not signatory to any written contract between the parties. Is the factor of being the signatory such a relevant factor or not? Because I think if you see Cox and Kings, the requirement of a party to really sign an agreement physically has been significantly watered down. So I don't see where your first submission is taken.
Indeed. My submission to that question is that the first and the primary point is that parties to an arbitration agreement must be the signatories. The scope of an arbitration agreement may be extended, and that could take place through various documents. For example, assignment, for example, group of companies, for example, implied consent. My learned friend's case is on the basis of implied consent. To that point, it is our submission that by virtue of its conduct and by virtue of no legal relations being existing between AI and the parties, there is no indication that AI is bound by this arbitration. Therefore, even if the scope were to be extended, were to be sought to be extended, it cannot, because AI has never consented. If I may proceed. Indeed. The second question before this tribunal is the question of what is the seat of this arbitration. It is our submission that the reading of Article 20, a purposive reading, would show that the seat is India. If the tribunal would look at Article 22, the tribunal there, Indeed. This is the article which is the basis of this entire controversy. The bare contractual provisions and the contractual position that emanates from Article 22 is this. First, that the FPP shall be governed by the laws of India. This appears in Article 22(p). Second, that the Indian Arbitration Act shall be the curial law governing the arbitration. This appears in Article 22(c). Further on, the venue shall be Singapore and the proceedings are to be conducted in accordance with the rules of SIAM. My submission is that there is an absence of an explicit provision for seat. Therefore, this tribunal may exercise its power under Rule 21.1 to determine the seat of this arbitration. And secondly, on a reading of the effect of the Indian Arbitration and Conciliation Act, this tribunal may come to a finding that the seat of this arbitration is India. Members of the tribunal.
Isn't it the usual way of choosing a seat to just say arbitration in London, arbitration in Singapore? Isn't that normally the way we choose a seat?
This tribunal is correct. This tribunal is right in saying that it is always better for a seat to be mentioned explicitly in an arbitration agreement, and that is also provided in the model clause under the CI. However, in this case, as we are called upon to interpret the parties' intentions under Article 22, the provisions under the contract provide that there is no seat, and therefore we have to have a purposive interpretation or a harmonious construction of these provisions. Our solution is that venue shall be Singapore cannot in any way mean that the seat of this arbitration shall be Singapore. I sense a concern.
What was the purpose of identifying Singapore twice over, like my learned arbitrator said that it's quite common in arbitration agreements to say arbitration taking place in Singapore or in India, and that is sufficient to signify that the parties actually intended that should be the seat. So if that being the case in the first instance, that was clarified to be the seat, and then they said, okay, for venue, we will also have the venue in Singapore because of the whole conundrum between seat and venue, so they've specified both in this case.
Indeed. To address this question of this tribunal, I may first admit that this tribunal has no forms with 22C mentioning venue. Now, I'll try to address this tribunal on 22A and particularly the phrase arbitration in Singapore. The phrase arbitration in Singapore must be read along with the remainder of the words in that sentence, which is arbitration in Singapore in accordance with the rules of CI. If this tribunal were to look at it in this way, it is evident that it is a mere iteration of what the parties had intended to do in Article 22C. Singapore is merely the venue of arbitration here. In any event, in the cases of Naviera, in the cases of DNA, courts have interpreted that arbitration in a particular place would mean that that would naturally be the seat of the arbitration. However, there is a key distinguishing factor in these judgments. The distinguishing factor is that the curial law of the arbitration in the arbitration agreement was also the same of the seat. Therefore, for instance, in Naviera, the arbitration agreement provided that arbitration the phrase was arbitration in London, and the English laws were to govern the arbitration. That is not the case in Article 22. Article 22 mentions arbitration in Singapore. However, it also provides for the application of the Indian Arbitration and Conciliation Act. My submission is, on a bare reading, even if this tribunal were to presume that Singapore is the seat of the arbitration, that presumption can be refuted by the presence and application of the Indian Arbitration and Conciliation Act. Questions and concerns?
But it is possible to have a seat in one jurisdiction, but the lex arbitri not be the lex arbitri of that jurisdiction.
Indeed, that may be a possibility. However, in this present case, it is my solution that is not the intention of the parties. And that brings me to my second solution. The Indian Arbitration Act, under Section 2, provides that the Part 1 of Indian Arbitration Act shall only apply to arbitration seated in Singapore, in India. As this tribunal has already raised this concern, an amendment was carried out in Article 20, in 2015, where sections 9, 27, and 37 were incorporated to apply to all arbitrations, be it seated in India or foreign seated arbitrations. The intention behind this amendment was to incorporate interim release or an appeal provision merely. That was not the intention of the amendment was not to apply the provisions of Part 1 to all foreign seated arbitrations. My submission is parties were aware that the provisions of the Indian Arbitration and Conciliation Act, Part 1 particularly, only apply to the territory of India. After being aware of this fact, they have still pursued and they have still provided for the Indian Arbitration and Conciliation Act to be the peculiar law of this arbitration. Therefore, it is our submission that parties were at idem that India would be the seat of the arbitration.
What about the judgment in Enacon, Supreme Court judgment? They had considered arbitration in London to also include sea.
If I may, if I recollect correctly, in Enacon, India was in Enacon GmbH. The court was considering an arbitration agreement which provided that the venue shall be London. However, the provisions of the Indian Arbitration and Conciliation Act would apply.
You're right about that, but in dealing with the submissions of Dr. Singhvi, there was an observation of the Supreme Court that though the venue of arbitration proceedings to be in London cannot be read from arbitration in London under the clause, but so far as the arbitration in London can be understood to include venue as well as seat. So there was some distinction drawn in Enacon on that.
Indeed. My submission is, in Enacon, that was the case. However, the judgment of the MP in Enacon turned on the fact of the closest and real connection test, which is that the territory or the country which bears the most close and real connection with the arbitration would be the territory that is the seat of the arbitration. And applying those principles in Enacon to this present arbitration, it is our submission that Article 22 provides that the substantive law of the contract would be India, the arbitration procedure would be the law of India, the agreement was entered into in India, the agreement has to be actually performed in India. The subject matter of the agreement are in India. Therefore, it is clear without any doubt that this arbitration bears its most close and real connection with the territory of India. Therefore, applying the principles of Enacon, it is clear that this arbitration is seated in India. Questions, sir?
Yeah, this is just a very short question. Let us say we agree with you that this is an Indian seated arbitration, and this tribunal were to render an award, and you also have a counterclaim in this arbitration against the claim. Would you be able to enforce that award in Germany?
We would
asked to stay the proceedings till the IBC proceedings are going on.
Madam Arbitrator, it is our submission.
It's a practical matter, whether or not and we do it. But given that there is a moratorium in place, we don't suspect that so rights are anyway protected, going to be protected on. So the application has been made so to put the proceedings before us in advance.
Madam Arbitrator, the given question follows through with the previous submission that was made, that we seek the protection of the goods in order to seek and enable the arbitral tribunal to render an award which eventually comes in our favor. And once that award is rendered in our favor, we could submit the thing as a claim to NCLT, right, which will allow us to seek money as a creditor. So the goods, it is observed that we are only seeking the protection of the goods till the end. If the only security we have is sold to a third party, the claim that we seek would not be derived from the money that would eventually be obtained by selling the HTBCs. Thus, it is our submission.
Do you have any decision where the NCLT proceeding party has claimed an award and has not gone through the 48 proceeding at all? Like what happens to the right of a party to resist the enforcement of the report? Would that be for good because you're not proceeding under 48, the will state as a claim in the instance? Enforcement. If they want to resist enforcement on any of the grounds against the award, what happens to that? They would not be able to do that for the NCLT.
Madam Arbitrator, it is our submission that as every creditor is entitled to the right to seek the amount that they are due, it is our submission that by seeking a recourse which eventually commercially permits us to seek the claim that is due to us, we would be seeking the same. And it is true that they would not be able to resist the enforcement of the award, but we as a commercial entity also want the payment of the dues that are not being paid to us.
But you do not be insured only once it is allowed to be enforced, and thereon then you come in, you pass the 48, then you can come under the NCLT without